This is a special report from True Crime Today and the Hidden Killers podcast.
I'm Tony Bruschi. Thanks for joining us. A courtroom battle took place today, bringing to the forefront the case of the tragic boat crash in 2019 that resulted in the untimely death of 19-year-old Mallory Beach. Beach's family has lodged a wrongful death lawsuit against Alec Murdaugh and Greg Parker, owner of the Parker's Kitchen convenience store chain. As the litigations proceed, the nexus of the Murdaugh family's alleged misconduct and the fatal accident becomes even more pronounced. This is the audio of that hearing, which took place today. Take a listen.
We're on the record in 2019's CP 2500111. Renee Beach is personal representative of the estate of Mallory Beach, representing Renee Beach in the estate is Mark Tinsley, Tabor Vall, and John Nichols. They're present here in the courtroom versus Greg Parker Incorporated. He's represented by Mr. Shearer and Mr. Williford. Y'all have anybody else here?
Yes, sir.
Okay. And I believe Dawes Cook is the attorney for Richard Alexander Murdaugh. He indicated, sent word that he would be running a little bit late. He was not opposed to the court proceeding with the hearing this morning as he makes his way here. I think the first matter we had that when we talked briefly before we started with the attorneys, Mr. Tinsley, I believe you had a motion or something you need to put on the record in regard to the estate of Paul Murdaugh.
Yes, Your Honor. This last week, we filed a motion to dismiss the claims against the estate of Paul Murdaugh. As you recall, Paul Murdaugh wasn't named as a defendant, but due to some of the financial concerns and things that were going on in the fall, we filed lis pendens, and then after the murders, we added the estates in order to identify whether or not the estates were being used to hide assets that belonged to Alex Murdaugh. We have investigated that. There are no assets in Paul Murdaugh's estate that belong to or are owed to or have been used to hide assets. And based on that discovery, we have asked the court to dismiss the claims against the estate without prejudice. Paul Murdaugh's estate's lawyer, David Overstreet, is here and consents to the motion, and I think now Parker's is finally consenting as well.
And when I call on you, too, if you would tell us your full name. The court reporter doesn't know all the attorneys. She needs to be sure that she has that.
Yes, sir. And for the record, my name is Mark Tinsley, and I represent the Beach family.
Right. Mr. Overstreet, you're here on behalf of the estate of Paul Murdaugh. I'll be glad to hear from you.
Yes, Your Honor. David Overstreet, Earhart Overstreet, on behalf of Randy Murdaugh, SPR for the estate of Paul Murdaugh. We obviously consent to Mr. Tinsley's motion for non-suit without prejudice against the estate.
All right, thank you. Mr. Shearer, do you wish to be heard?
Good afternoon, Your Honor. P.K. Shearer here on, with the law firm of Huff Powell Bailey. I do not wish to be heard, Your Honor. We have no objection.
All right, thank you. Then, Mr. Tinsley, if you'll e-file the appropriate order, and then I'll sign that order when it's in my queue.
Thank you, Your Honor.
All right, I think the next matter before the court is scheduled is there are two motions that are pending in the case brought on behalf of Greg Parker Incorporated. One motion is the defendant Greg Parker Incorporated's motion to sever, and then additionally Greg Parker Incorporated motion to change venue. So, Mr. Shearer, I'll be glad to hear those in whatever order you deem appropriate.
Yes, sir. Thank you, Your Honor. We would prefer to start with the, excuse me, the motion to sever, with the court's permission.
All right. I'll be glad to hear from you.
Thank you, Your Honor. Good morning. May it please the court. Your Honor, I'm not going to spend a lot of time talking about the facts of this case. Obviously, the court and, frankly, the state, the nation, and maybe even the world knows about the facts of these cases. We initially, on behalf of Parker, sought severance from this court back in August of 2022. Your Honor, as you're well aware, that Your Honor granted that motion and issued a very detailed order dated September 13th, 2022. And then ultimately, Your Honor, after granting the motion, reversed it 2 weeks later. Without reading the entire order in its entirety to this court, Your Honor, you're aware that you decided on page 5 of the order.
I have the file here in front of me, so if I'm looking down, I don't mean to be showing anybody any disrespect.
Yes, sir.
I'm listening, but I'm reading along with you as
Yes,
you're
sir.
going through it. All right, go ahead.
On page 5 of your order, Your Honor, this was the order granting the original severance. It says in the middle of the paragraph there, and if there was ever a case in which a court may exercise its sound discretion to order separate trials to prevent delays or prejudice, this is it, based on the facts and circumstances involving the parties in this matter. Your Honor, at that time, you made a decision to sever Parker's away from multiple Murdaugh defendants. At that time, Your Honor, as you're aware, the estate of Paul was there. Alec Murdaugh was also a named defendant. Buster was a defendant. The estate of Maggie was a defendant at the time as well. And so at this time, the law and the facts are generally the same, Your Honor. But there are some material things that have changed the dynamics. As Your Honor would remember, that at the time that we moved for the first severance, Alec Murdaugh was indicted, but he was not convicted of the murders of his son Paul and his wife Maggie. Since that time, and since the original severance and the reversal, what is different now? Standing here today, we now know that Alec Murdaugh has been convicted of murdering his wife Maggie and his son Paul, who at the time were co-defendants of Parker's. The media frenzy surrounding Alec Murdaugh and his murder conviction has gone beyond South Carolina, beyond the Southeast. It's gone national and global. The plaintiff has settled and dismissed everyone else. They just recently, as the court just heard, are now dismissing without prejudice the estate of Paul Murdaugh, who was driving the boat that ultimately killed Mallory Beach on that tragic night. And so we sit here now with Parker's and Alec Murdaugh as the remaining co-defendants in this matter. The prejudice, Your Honor, that was present at the time that this court, we believe, appropriately severed the case, so severed Parker's away from the Murdaughs, is still present. It's worse. And more importantly, with all these dismissals, it's more concentrated, Your Honor. We have one co-defendant, a convicted murderer, who's convicted of murdering his wife and his son, his son, who was Timmy that night and drove that boat and ultimately killed Mallory Beach. The court may recall that when we argued the first severance motion, there was the law that talked about separate and distinct claims. And again, I'm not here to repeat. The law is the same, Your Honor. The rules and the laws are the same. It's just the application of those rules and the laws now are certainly different. On page 4, Your Honor, of your order, you wrote, quote,
Let me be sure the record's clear. That is a motion, that is an order that I heard a motion to reconsider on. I looked further at the law and the motion and everything that had been filed in that case and the facts of the case, and I did. That's fine with you to keep referring to the order.
Yes, sir.
But the court reversed its
Yes, sir.
ruling and and did not sever the case.
Correct.
All right, go ahead.
Yes, sir. And to put that in context, Your Honor, when you did first look at it, this was the order, and I want to put it in the context now of why when you look at that same law and you look at the same facts and things that have changed, why going back to your first order makes perfect sense to sever away from the only remaining co-defendant, who's Alec Murdaugh. But on page 4, Your Honor, it says there in the first paragraph, 5 lines up, it says, further, plaintiff's claims against Parkers are separate and distinct, such that plaintiff may fully try her case against Parkers during a trial separate from the Murdaugh defendants. Now, that was back when it was all of the Murdaugh defendants. Now, it's just Alec. So if we look at that issue, Your Honor, as separate and distinct, at this point in time, we have Parkers and Alec Murdaugh. There are different claims and different allegations as to those two defendants. And I remember, Your Honor, when I first got involved in this case, it seems like forever ago, but I remember Your Honor saying, we're going to treat this just like a dram shop case. And this was before Alec Murdaugh had even been, I think he was maybe indicted, he had not been convicted of murder, but we're going to treat this as a dram shop case. At this point, Your Honor, the claim against Parkers is pretty simple. It's plain and simple. It's whether or not the transaction that happened at Parkers, which we believe followed the law, that she checked the ID of Paul, thinking that it was Buster. She looked at it, she scanned it, and she made a valid legal transaction. We're not here to talk about all the facts of the case, but that's really it. They're alleging that that was not done appropriately. That is it. And whether or not that alleged negligence was a cause of Mallory Beach's death 8-9 hours later, after they had gone to the oyster roast and all the other things, and gone to Luther's. But again, I'm not here to talk about and debate all the facts with you. It's about what the allegations are. So the allegation is that that transaction should have been done differently. But if you look at what the claims with the only remaining defendant, co-defendant, Alec Murdaugh, they are that, and this is in the amended complaint, Your Honor, on page 9. Does Your Honor have a copy of that? I have that.
I do. I have it.
Okay. On page 9 of the complaint. But if you look at what the allegations are now for our Alec Murdaugh, it's that he willfully allowed his minor son, Paul, under the age of 21, to use Buster's driver's license. That he failed to supervise Paul when he knew or should have known that Paul was using Buster's license. That he gave him a credit card to illegally purchase alcohol. That he negligently entrusted him with a boat when he, Alec Murdaugh, should have known that Paul drank to excess and was an unfit, inexperienced, or reckless boat rider. So it's a transaction versus essentially bad parenting. And knowledge that Alec Murdaugh had about his own family. Not knowledge that Tahisha Cohen, the customer service rep, would have had, or Parker's, but what was it? Bad parenting, negligent supervision. Those two claims are absolutely 100% different. And the evidence and the way that the trial would move forward would be absolutely different against Alec Murdaugh as it would be for Parker's. It's a cleaner case, Your Honor. It's a clean case. It's a dram shop case, if you want to, as far as the claim against Parker's. The claim against Alec Murdaugh is the media frenzy. It's a separate claim. And Your Honor, if you go back and look at the law again, that is one of the main things that they were talking about in the cases, is that it needs to be separate and distinct. And those are separate and distinct. Now, Your Honor, one of the things that you had mentioned, and I remember this from the motion for reconsideration, was how does this severance impact joint and several liability? This court is, I think everyone is very well aware about why Alec Murdaugh and Parker's are the only two remaining defendants at this point. It's joint and several liability. In South Carolina, if Parker's is found 1% at fault, they're going to pay the entirety of a verdict for the sins of the Murdaughs. And that's why they're there. Your Honor, Mr. Tinsley fought hard to tether us back to Alec Murdaugh and the Murdaughs for one reason, and that is to infuriate a jury, to get a jury mad at Alec Murdaugh and everything that surrounds Alec, the murderers, and everything else, to get a jury infuriated with him and then have Parker's pay for it. Your Honor, in looking at joint and several liability, we now know that, and Mr. Tinsley just admitted it, we filed a lawsuit against the estate of the driver of the boat that killed Mallory Beach because we wanted to make sure they weren't hiding money and shuffling money around in an inappropriate way, that there are no assets. But the minute they found out that wasn't there, it wasn't about seeking justice from the person who killed Mallory Beach. It was about the money. And Mr. Tinsley just dismissed him. And the court's going to execute that order, and Paul Murdaugh, the estate of Paul Murdaugh's gone. They've settled with some of the people from Luther's and the Woods family, the Oyster Rose, the Trust. They've settled with all those people. Your Honor is very well aware that Alec Murdaugh doesn't have any money. Your Honor's been in charge of the proceedings regarding the receivership. So essentially, the reason why Mr. Tinsley has fought so hard to keep Alec in this case is because we now have a 100% judgment-proof co-defendant who's murdered his wife, murdered his son, and he wants us there together so that a jury can get angry about that, and the only person who could pay for it is the deep pocket Parkers. Your Honor, the point of joint and several liability is not punitive in nature. And what I mean by that is that joint and several liability is for the Beach family to get a fair trial and to be compensated if a jury believes that Parker's was negligent. At this point, we know that there can be a fair trial against Parker's. It's a dram shop case. It's one that Parker's is prepared to defend. And if a jury believes that that Parker's was negligent, and that negligence was a proximate cause of Mallory Beach's death 8-9 hours later, then the jury can render that verdict, and subject to any appeals and things like that, there is a company that they could seek damages from. But to tether Alec Murdaugh and the Parkers solely for the reason of getting that jury infuriated is not the purpose of joint and several liability whatsoever. It's not punitive in nature. Severing Parkers away from Alec Murdaugh, Your Honor, would allow a jury to address the dram shop part of it. That's what this case is about as far as Parkers. It is not about bad parenting. Your Honor, the liability that Alec Murdaugh is being alleged to have had in this case is indirect. It's indirect liability to anything related to the transaction and all of the events thereafter. It's indirect. And that's why they're separated that way. And we know that is the only reason why Mr. Tinsley wants Alex Murdaugh in this trial is for that jury to see him. And we just saw, I mean, he was convicted of murder in a very short period of time. There's a lot of people who have strong opinions about it. And Your Honor, I would say this, that, you know, when we, and there's a little bit of overlap with the motion to transfer venue, Your Honor, so I won't argue that completely at this point. But when you talk about, during jury selection, you know, if you're asking jurors questions and you say, hey, this case is about a breach of contract or it's a dog bite case, that's one thing. This is a case involving a family and now a gentleman who's sitting in jail for the murder of his wife and his son, with centuries of the Murdaugh influence here in Hampton County. Many times good, more recently bad. Everyone has a strong opinion about it. And there is simply, this court is well aware, Your Honor, the number one goal of the judicial system here is for each party, and that's not just the plaintiff, each party, including the defendant, and that includes Parker in this case, to get a fair trial. Your Honor, I think that we can't use the audio system here, but I do want to play this one. Hopefully the court can hear it. But this is just to put it in context. As you know, I mean, there's a lot of media here. There's media right outside of the courthouse. A lot of interviews being given about this case. But as it relates to this very issue of severance, Your Honor, I'd like the court to hear this from Mr. Bland, Eric Bland, who was involved in the Satterfield matter. Go ahead and play that.
Intoxicated or watercraft. And it's going to be a fascinating trial. If Alex Murdaugh does come to the trial, you know, he's sitting at the defense table with Parker, which means he's going to get the stink. Parker's going to get the stink all over him from Alex Murdaugh just being 2 feet from him in a jumpsuit. I'm not sure they're going to let him wear a suit, a business suit. They may. But just the fact that you're at the same defense area or table with Alex Murdaugh will really resonate with the jury.
You have about 30 seconds.
Yeah, I'm well aware of that. I'm aware of that. For purposes of this hearing today, I'd rather not hear any videos of other lawyers giving their opinion about the case. I'm well aware of where we are, so let's don't have any more of those.
Yes, sir. I will say this, and as far as the stink, that's what this court should be concerned about. It's the reason why we have filed this motion to sever. Circumstances have changed, Your Honor, and we are here to get a fair trial for Parkers. And so, Your Honor, based on the change in circumstances, the applicable law, the claims that are remaining, and the clear prejudice that Parkers would face, being tethered again to a convicted murderer, we would ask that this court sever Parkers away and let us try our case with the Beach family.
Thank you, Mr. Tinsley.
Your Honor, I can't pass up this opportunity, and I suspect that no one's ever quoted people.
Mr. Cook, you want to take a spot up here inside the bar? Thank you. All right, you're good.
Yeah, thank you, Your Honor. I suspect no one's ever quoted Pee Wee Gaskins to you before, but I'm going to quote him now. Fairness and justice are dependent on your perspective of whether you're giving it or you're getting it. And if you look at, I'm not going to go back through our whole motion to reconsider. In the brief, I extensively briefed everything he's just talked about, but I'm going to point out a few things. You can't come in to a situation, a case, pour gasoline on something, set it on fire, step back, and then claim that you have unclean hands. In the motion to disqualify me, I filed with Your Honor the blog, the 28-page blog that Greg Parker's employee filed and made public in July of 2021, after the murders, containing inside information only available to the lawyers. Mr. Parker has sat with the Wall Street Journal. He sought the Wall Street Journal out to make this subject the focus of worldwide attention. He sat with Dateline. He sought them out. He sat with Netflix. He sought them out to give his statement. To the extent that they argue there's some change in circumstances and they have unclean hands and all this attention, the facts don't support that, Your Honor, and there's no evidence in front of you that would support that conclusion. And that's really the point. If you look at, for instance, Smith versus Tiffany, every single case that's cited in the brief before where a defendant claims that the 200 years of settled law in this state, that the plaintiff is the architect of her complaint, of her case, of how she presents her case when it's an indivisible injury, like a death, and common issues of questions of law and fact, and they are in fact that she gets to decide. She is the architect. In every one of those cases, the Supreme Court has addressed this idea that there's some unfairness. We have a system that encourages the resolution of lawsuits. They have the keys to the jail. The fact that he refuses to avail himself of it is exclusively Mr. Parker's making. There's simply no evidence before this court to support any conclusion that he's argued. Alex Murdaugh's great-grandfather, Alex Murdaugh's grandfather, Alex Murdaugh's father are right here. Alex Murdaugh is not sitting on the side of the plaintiff, and Alex Murdaugh is not conceding liability, he is contesting and fighting liability. And only Mr. Parker thinks that the funds in the receiver account are judgment-proof or nothing. Any risk of prejudice in this case from Alex Murdaugh's involvement in this county where people still may believe that he was wrongfully accused, he was convicted of murder because he was in fact guilty. And there is no basis for this court to conclude any prejudice either to Parker's or to Alec as a result of that. If he can get a fair and impartial trial in Colleton County, which is in the 14th Circuit, which is affected with the same influence that they argue that this case is infected with, he can get a fair trial here. They will get a fair trial. I'd submit to the court that the prejudice is more likely to the plaintiff than it is to the defense by Alex Murdaugh's involvement in this matter. But there's no evidence of that, Your Honor. And they can stand in here, and much like they're going to do with the motion to transfer venue, there simply is no evidence. And they can't show that. Smith versus Tiffany, and I've cited it to you before. It's 419 South Carolina 548. It's 2017 Supreme Court opinion. The Supreme Court recognized that the court cannot usurp the the legislature's authority to enact policy. And in this case, because we have the contribution among joint tortfeasors section that specifically makes joint and several liability, but still the law of this land, and which has been the law for over 200 years, they are asking you to violate the separation of powers. And the Smith case recognized that that is an additional basis in addition to the 200 years of authority that support that the plaintiff gets to make the decision. And these are the same issues. They blame the Murdaughs. They say Paul Murdaugh is not the driver. All of these issues are common issues. And you cannot, now, I thought it was interesting that he stands up and he tells Your Honor that the law and the facts are the same. But just there's a change in circumstance. There's no change in circumstance. And now, in their brief, they seem to be proposing 3 trials. The Morrow case, I cited it to Your Honor before, Morrow versus Fundamental Long-Term Care, 412 South Carolina 534, 2015 Supreme Court opinion. That was the case where the trial court said that, this is a nursing home neglect case, in the first instance, we have to decide whether there was neglect. If there's not neglect, for which the nursing home company can be vicariously liable, there can't be liability for its own corporate acts. It's the same thing here. And the Supreme Court found that not only did that view of the claim, the plaintiff's claim, violate the plaintiff's 7th Amendment right to a jury, But it in fact upset this 200 years of settled law that the plaintiff is the architect, and it runs the risk of potential inconsistent verdicts. Beyond that, Your Honor, they continue to talk about Rule 20, but they're not asking you to sever it now. They're putting that label on there, and the Morrow case says you can look through that label. What they're asking you to do is bifurcate this. And it is improper under Rule 20. It's improper because, again, I argued to you before, a claim, their defense's claim of blaming Paul Murdaugh or saying that he's not the driver is in fact a claim broader than the right to relief referenced in the rule and makes Rule 20 inapplicable. If you look at page 13 of the motion to reconsider, that whole page is about the subject, Your Honor. I don't need to recite it now, but Rule 20 is inapplicable, Rule 42 is inapplicable because these are the same issues. Thank you, Your Honor.
All right, thank you. All right. If you have something new to offer, I mean, you know, the court has been through this at prior hearings. There's been lots of briefs filed. If you have something new that you'd like to respond to, I'll be glad to listen to you.
Yes, sir. Very briefly, Mr. Tinsley has said that the plaintiff is the architect of his or her complaint, and would argue to this court that they're allowed to do whatever they want and the court can't have any control over it. If that was true, if the plaintiff is the architect of the complaint outside of the available rules that this court has, how on earth would there even be a rule to sever? It doesn't make sense. Yeah, they could sue whoever they want to, but the court has the discretion to say, hey, in this case, you could sue whoever you want to, but our role as the court is to make sure that whoever you're suing is getting a fair trial. And I'll lastly say, Your Honor, Mr. Tinsley said there's no change in circumstances. I would beg to differ that a conviction of murder of your wife and your son is certainly a change of circumstance from the first severance. Thank you.
All right, thank you. All right, now let me hear you on your motion for change of venue.
Yes, sir, Your Honor. As I mentioned, you know, the motion to sever and the basis for the motion to sever are also somewhat intertwined and overlap with the motion to transfer, Your Honor. Under South Carolina Code 15-7-100 A2, we recognize that this is in the discretion of the court. Your Honor may be familiar that originally there was a motion to transfer in January of 2020. That motion was based on convenience of witnesses. This motion, as Your Honor is aware, is for prong 2, which talks about the ability to get a fair and impartial trial. So it's different from the first one. I think some people have said, well, you filed it before. What's different? But it's a different motion, Your Honor, as you know. Your Honor, per that rule, you have to get an affidavit from a Hampton County resident to say that they believe that you cannot get a fair and impartial trial here. And that's not easy to do. We were able to get 2. I understand that Mr. Tinsley just this morning, right before the hearing, has something to suggest that one of the folks who gave an affidavit, Miss Brown, may not have property here in Hampton County. She reported that she lives here part of the time, but more importantly, Your Honor, we have the affidavit of Mr. Rant, who's been a resident of Hampton County for 60 years. And the point of the affidavit is not to go and talk to every single resident of Hampton County, because there's a lot of people who don't even want to talk about this. But the affidavit gives you the ability to at least file the motion, which is what we've done. Your Honor, we do believe that the notoriety, I was talking about jury selection. Now, again, in this case, in this county, we know the Murdaugh name has influence. Everybody's going to have an opinion, one way or the other, whether it's good or bad. But there is an opinion. And again, Your Honor, it would be one thing if we're talking about a breach of contract case here, and the Murdaughs may be involved. We are talking about Alec Murdaugh, who practiced law here, who had a firm here, who is now convicted of killing his wife and his son in a trial in Hampton County. There is no resident in Hampton County that hadn't heard about it, hadn't talked about it, hasn't watched the news about it. And Your Honor, we would submit that, again, at the time that the first motion was filed, which was for convenience of witnesses, that was at a time when Alec had not been indicted, I don't even think. Paul was still alive, Maggie and Buster and all the other defendants were there. Now again, we're here with just one co-defendant, who's Alec Murdaugh. Your Honor, we do believe that the case of State versus Manny Lee Law, which is 265 South Carolina 111, which is cited. One of the things that we anticipate is that when you do transfer venue, that it needs to be moved to a county in the judicial district, in the circuit. Your Honor, as you can tell from our motion, we're asking for it to be removed from the circuit completely, given the fact that just right down the road in Colleton is where Mr. Murdaugh was convicted. And more importantly, Your Honor, what that case stands for is not only that transferring venue is appropriate and within the discretion of the court, but that also the Constitution of South Carolina, first and foremost, requires an impartial trial for the defendant. And Your Honor, Section 23 says it shall be the duty of the General Assembly to pass laws for the change of venue in all cases, civil and criminal, upon proper showing supported by affidavit that a fair and impartial trial cannot be had in the county where such action or prosecution was commenced. Your Honor, that's the basis for our motion. Again, it's intertwined with the facts and circumstances of our motion to sever. We believe that, and I do want to say this, Your Honor, it is not that we don't believe that folks from Hampton County can't be fair. It's the type of case. Again, this is a case about a breach of contract. We're not even having this discussion. We're talking about Alec Murdaugh and the Murdaugh dynasty and the Murdaugh family here in Hampton County. That's the reason. Not because they can't be fair. It's because every juror brings their life's experiences to the box. And that life experience here in Hampton County is going to be, to use Mr. Tinsley's term, it's going to be infected with all of the media hurricane that is the Murdaughs. And so, Your Honor, we would ask that there be a transfer venue.
All right, thank you. Before I get to you, Mr. Tinsley, Mr. Cook, I'm going to listen to Mr. Tinsley, and then I'll give you an opportunity to respond. I cut you off and didn't hear you on the first motion. I'll hear you on both motions after Mr. Tinsley finishes. Mr. Tinsley.
Thank you, Your Honor. Judge, Mr. Scheer says that the rule requires an affidavit. The rule, the law, the Constitution require a formidable showing, a showing that it is truly impossible. This is Alston versus Black River Electric Co-op, 345, South Carolina, 323, South Carolina Supreme Court opinion from 2001. It's truly impossible to strike a jury in which the jurors, the venire, will either say that they will follow the law, say that they will abide by their oath, and follow Your Honor's instruction. An affidavit, he says, in the fill-in-the-blank affidavit they got from, he said Mr. Rant, it's Gerald Brandt. I know Mr. Brandt. Even if you were to consider this affidavit, and let me jump back to Ms. Brown. Ms. Brown, in the fill-in-the-blank affidavit, it says that she's a resident, because that's what Mr. Shearer wrote on it. But then she had the wherewithal on the last page to say, well, she lives in Florida. She's got some property here. It's not uncommon that people have hunting property here, and they're up here periodically. And she watched it on the TV, and she knows what she knows. There's no evidence there. Mr. Brandt's affidavit is equally unable to establish any of the formidable obstacles he has to establish. And if you look at the case of Stevens versus the Sun News, the Supreme Court talked about what a formidable burden that is. And it was in the context, in that case, they actually used attorney affidavits. They used the senator's affidavit, and it talked about the inability of the Horry County to give a fair and impartial trial to the plaintiff in that case. And the Supreme Court noted that, that those statements, the same statements that are outlined in Mr. Shearer's fill-in-the-blank affidavit, are mere conclusory statements. There is simply no showing. So I would submit to the court that he hasn't even met his initial burden of an affidavit that you can consider if you look at the Stevens case. But beyond that, Your Honor, again, he is asking the court to assume that the people of Hampton County will not follow their oath, they will not follow the law, and you simply can't assume that. The idea that there's worldwide attention, there's nationwide attention, there's statewide attention to this, where would we try it, Your Honor? Where would he go and find people who've not heard about it? Every case I've ever tried, the court says, do you know anything about this? Do you know anybody in this? And then ultimately, can you set that aside and listen to the evidence that comes from that chair right there and try this matter fairly and impartially? It may be come August the 15th, after we've been through all of the people who show up, that a change of venue would be appropriate at that time. If we are unable to select 20 people, which is what the Constitution requires, 20 people from which the strikes will be exercised, if we can't find 20 people in Hampton County, and there's no question that we'll find 20 people. There's no question I think we'll find more than 20 people in the first panel. But there's no evidence in front of this court that supports this baseless argument that they're making today, and we'd ask you to deny it.
Thank you. Mr. Cook, on behalf of Alec Murdaugh, I'd be glad to hear from you.
Thank you. On both motions, on the motion to transfer venue, Your Honor, just briefly, his view is that there's really no place in the English-speaking world that you can transfer the case where people haven't heard about it. And reluctantly have to agree with Mr. Tinsley that we're going to have to rely on the integrity of the jury and good voir dire and jury selection to find a panel that can put aside the other things surrounding the Murdaughs and focus just on the facts of this case. So for that reason, we have not joined in that motion to transfer venue. As to the motion to sever, Your Honor, the one interest we have is that we believe that under the Contribution Among Joint Tortfeasors Act, Mr. Murdaugh is entitled to have his liability, if any, reduced by the liability of others. Partners can't, because their liability arises out of the sale or use of alcohol, and that's one of the exclusions under the Act. But we're going to take the position that that doesn't apply to Mr. Murdaugh, and so it would complicate the trial if you had separate trials with partners and Mr. Murdaugh. So for that reason, he opposes the motion to sever.
All right, thank you, Mr. Cook. Any further argument? All right, we're going to take a 15-minute break.
Thank you.
All right, take your seats. All right, I appreciate the arguments that have been made today, and just want to remind everybody, Judge Halls was appointed to this case more than 4 years ago. I'm well aware of the particular facts, the positions of the parties in the case. The lawyers have, up to this point, have done a very excellent job of educating Judge Hall on the law and areas of the law, and I'm sure that's going to continue going forward. Educating me on the issues in this particular case. Today, and I've had plenty of time before today, in addition to the oral arguments, to review all the briefs, the rulings I've made in the past, the arguments that were made on the briefs, motions that had been filed in the case. Based upon that, on Greg Parker's second motion to sever, I deny that motion, and Greg Parker's motion to transfer venue, the court denies that motion as well. I want to remind everybody, those that are in attendance, the court certainly doesn't find any fault with attorneys filing appropriate motions, hearing those motions. They're doing their job. These are excellent lawyers on both sides of this case. Makes it a pleasure to serve as a judge in this type of case when you've got really good lawyers. There's no fault for these attorneys filing these motions. They're good lawyers doing their job. I do believe that the courts in South Carolina have had plenty of experience in dealing with very high-profile cases in the venues they occurred. Certainly, the Dylan Roof case would be a pretty prime example of a case that was held in the venue in which the atrocious acts occurred, and a local jury in Charleston County heard that. They gave a fair and impartial. They were fair and impartial jurors. I'm sure that's going to be the issue in this case. I'm sure is probably the issue over in Colleton County. The clerk of court is making every effort to provide the appropriate number of jurors. Hopefully the court has full confidence that we'll find jurors here in Hampton County that take their oath seriously, will be able to listen to the evidence, and based upon the evidence, what they hear in this courtroom, to render a fair and impartial verdict. So I will simply file two Form 4 electronic orders stating that both motions have been denied, and those will be electronically filed. Thank you.
Thank you, Your Honor.
And one other issue, I would like some type of pretrial briefs pursuant to Rule 16, Rule of Civil Procedure, that Rule 16C. I would like those by the end of the month, no later than the end of the month. And I remind you, under that rule, those are briefs for the court. They are not to be filed. They're not a part of the record in the case. But I ask that both sides file the appropriate pretrial brief with all the information required in Rule 16C. And again, I remind you, the rule states that those are not to be made part of the record, not to be published. They are for the purpose of providing that pretrial information to the court. Have those into my office by the end of the month. At some point in time, we probably need to schedule a status conference on where we are. We won't resolve that issue today, but y'all may want to talk about that among yourselves. I'm flexible in to the extent I'm going to be in several different places doing criminal and civil cases between now and August 14th, but I'll do everything to adjust my schedule to meet y'all so that we can have some type of meaningful pretrial meeting in person sometime in the future. Anything else?
Yes, Your Honor.
Yes, Mr. Tinsley.
Mr. Cook has just filed a motion for protective order related to Alex Murdaugh's deposition, which is scheduled to take place on Tuesday. I'd like to take that up. I have moral objections to the order, and I can explain that. Mr. Murdaugh. Yes, sir.
That's the latest that we have for you. We will continue to cover this case as it continues to unfold. I'm Tony Bruschi. Thanks for listening.
This has been a special report from True Crime Today and the Hidden Killers podcast. This is the Hidden Killers Podcast.
Want more? Start binging on all of our true crime podcasts right now through Apple Podcasts and get an ad-free experience when you sign up to be a True Crime Today Premium Plus member exclusively on Apple Podcasts.
More of the Hidden Killers Podcast dropping soon.
Press subscribe now.